NFT prosecution brings up original copyright issues. The non-fungible tokens market is raising new protected innovation issues, including contending exposure freedoms to control one's name, picture, and similarity. Nixon Peabody lawyers Erica Van Crackpot and Joshua Pollack say that risk-aversion rehearses, for example, acquiring assent, are as yet the best road. Specialists make thousands and in some cases a great many dollars selling non-fungible tokens, some of which highlight VIPs or others. The craftsman might have protectable freedoms under the copyright represent their unique work, however the superstar depicted in the NFT has contending exposure privileges to control their name, picture, and resemblance. Whose freedoms win? To start with, some foundation. The Copyright Act bears the cost of copyright proprietors' selective freedoms to show, perform, recreate, or convey duplicates of a protected work, and to get ready subsidiary works in view of the protected work. In this way, when an independently employed craftsman snaps a picture of a VIP, the Copyright Act gives the craftsman the selective right to make and sell duplicates of that photo. Yet, shouldn't something be said about the superstar depicted in the photo? Do they have a contending right to control how their name, picture, or resemblance is utilized? Most states say okay. California, for instance, has long perceived a customary regulation right of security for the insurance of an individual's name and resemblance against assignment by others for their benefit, monetarily etc., like in Stewart v. Drifter LLC. California likewise gives a legal right of exposure that bars the knowing utilization of another's name, voice, mark, photo, or resemblance for reasons for promoting or selling without such individual's earlier assent. How are courts to accommodate the craftsman's copyright freedoms with the superstar's contending privileges of protection and exposure? The response lies to some extent in Segment 301 of the Copyright Act, which looks to seize and nullify any freedoms under the customary regulation or rules of an express that are identical to copyright and that stretch out to works inside the extent of the government intellectual property regulation. Two-section test. Courts utilize a two-section test to decide if a state regulation case is seized by the Copyright Act. As expressed by the 10th Circuit, a court should initially decide if the topic of the state regulation case falls inside the topic of copyright. In the event that it does, the court should decide if the privileges attested under state regulation are identical to the selective freedoms allowed to copyright proprietors under the Copyright Act. Whether an exposure right case in light of a protected photo falls inside the topic of copyright might turn on whether the photo is utilized for business purposes. For instance, the 10th Circuit has held that an exposure right case might continue when a resemblance is utilized non-consensually on stock or in publicizing. However, where a resemblance has been caught in a protected creative visual work, like a photo, and the actual work is being disseminated for individual use, an exposure right case is minimal in excess of a meagerly masked copyright guarantee and is seized. Under this methodology, on the off chance that a craftsman utilizes a VIP's picture non-consensually on stock, the superstar's right of exposure guarantee won't be seized by the craftsman's copyright freedoms. Yet, in the event that the craftsman makes a photo of the superstar accessible for download for non-business, imaginative use, the right of exposure guarantee will be seized on the grounds that it challenges the control of the creative work itself and falls inside the topic of copyright. And NFTs? Where do NFTs, including the picture and similarity of a VIP, fall inside this range? In the event that NFTs are simple multiplications of photos, the presentation and conveyance of NFTs seemingly fall inside the topic of the Copyright Act, and the VIP's right of exposure guarantee would be acquired. Yet, in the event that NFTs are unmistakable from the fundamental protected photo, they are the same than some other thing of product, and the VIP's exposure privileges ought not be appropriated. In a new choice, a government court expected that NFTs fall inside the topic of the Copyright Act in light of its comprehension that NFTs are but computerized portrayal of the fundamental resource, i.e., the photos at issue. A contention can be made in actuality. As another government court as of late noticed, NFTs are units of information put away on a blockchain that are made to move responsibility for objects or computerized media. All in all, NFTs have worth and exist freely from the fundamental photos they address, and a right of exposure guarantee coordinated toward an NFT ought to seemingly be treated for seizure purposes equivalent to one coordinated toward stock, for example, skateboards and shower drapes. In the next few long stretches of time, courts should determine the crash between a VIP or other's right of exposure and a craftsman's copyright privileges, explicitly as they connect with NFTs. Meanwhile, the issue will proceed to fundamentally influence VIPs and specialists the same. As this issue is as yet being chosen, risk-aversion rehearses still direct getting the assent of the copyright holder and the exposure privileges holder. This article doesn't be guaranteed to mirror the assessment of the Agency of Public Undertakings Incorporated, the distributor of Bloomberg Regulation and Bloomberg Duty, or its proprietors. Compose for us, Creator Rules. Creator Data. Erica J. Van Crackpot is a protected innovation accomplice at Nixon Peabody. As an accomplished IP preliminary legal counselor, she has a triumphant history contesting copyright, brand name, patent, freedoms of exposure, proprietary innovations, intrusion of protection, criticism, business obstruction, and different media and diversion claims. Joshua J. Pollack, a licensed innovation counsel at Nixon Peabody, is a preliminary lawyer with over 26 years of involvement effectively addressing clients in high-stakes prosecution in government and state courts the nation over that stretches out across a large number of organizations and businesses.